Hi, in this presentation we will discuss about patent examiner, office action and interview with patent examiner during patent application prosecution in patent office. Now let us start with office action. Office action during prosecution of patent application. Office action by examiner is a communication sent by examiner to applicant during examination of patent application. Office action includes objections raised by examiner to applicant during patent application, prosecution or examination. And these objections may be based on patentability issues like utility, novelty, obviousness, disclosure requirements, enablement requirements, claim definiteness requirement, best mode disclosure requirements, etc. So examiner will send office action in the form of any objections for patentability of patent application, which will be based on patentability issues like novelty, utility, obviousness, written description, etc. Applicants should effectively rebut or defend these objections sent by examiner well in time by providing either additional data or by antedating the prior art reference. Antedating prior art reference means by proving that your invention is prior to the prior art reference date. You made your invention before the reference date or prior art reference date. Applicant may even need for an interview with the examiner to clarify the issues raised by examiner. Coming to interview with examiner, it is within discretion of examiner whether or not to grant for an interview. So examiner will decide whether he wants to give interview to the applicant or not. Applicant should be careful about statements made during interview with examiner, because unnecessary statements, arguments or comments made during interview or during prosecution of application may create an estoppel, which is called prosecution history estoppel or PHE, and this estoppel will prevent applicant forever from later on claiming of whatever has been disclaimed or surrendered during prosecution of application, maybe by making unnecessary statements or arguments or comments with the examiner during interview or during the any communication made with the examiner. So one has to be very careful while prosecuting his patent application, especially during interview with the examiner. So one should be careful not to make any unnecessary statements or arguments or comments, because they will create estoppel. So whatever you have surrendered or disclaimed during patent application prosecution by these arguments, comments or statements, maybe during interview or during patent application prosecution. So whatever you have surrendered during patent application prosecution, that will create an estoppel. So whatever you surrender or disclaim, you cannot reclaim it again later on, maybe during court case or litigation. So that will create estoppel. So you have to be very careful not to make any unnecessary statement, comments, or arguments during patent application prosecution. Applicant must ensure that after interview, the discussion between examiner and applicant should be recorded in writing on paper as record in prosecution history file, which is also called file wrapper. Now coming to prosecution history. The prosecution history file is also called file wrapper, and this prosecution history file contains all responses and statements made by applicant during application examination or prosecution in patent office. So all communication in the form of statements or responses or letters will be there in this prosecution history file or file wrapper. Any unnecessary arguments or statements or comments made during prosecution of patent application may create an estoppel, as discussed in previous slide. So whatever arguments, statements, and comments you make during prosecution or during interview with the examiner, they will be recorded in this file, and they will be there in this prosecution history file or file wrapper forever. And anybody can get this file wrapper from patent office by paying the required fee. You can get file wrapper of any patent from patent office by paying the fee. So when any unnecessary arguments, statements, or comments made during patent office, during patent application prosecution, they will create an estoppel. Means whatever you have surrendered or you have disclaimed by these arguments, statements, or comments, they will not allow you to reclaim the surrendered or disclaimed matter later on, maybe during litigation or court case, because that will create an estoppel. That estoppel will stop you from reclaiming of whatever you have surrendered during patent prosecution, maybe through unnecessary statements or arguments or comments. That's why applicants should be very careful while prosecuting the application, not to make any unnecessary statement, argument, comments, because it will ultimately harm the applicant only. Whatever has been disclaimed or surrendered by applicant during prosecution will be in public domain, and it cannot be reclaimed later on during litigation, because it will create an estoppel, prosecution history estoppel for that matter. So whatever you disclaim or surrender during prosecution, it cannot be reclaimed later on, and estoppel will apply. Estoppel will stop you from later on reclaiming of whatever you disclaimed or surrendered during patent application prosecution. When amendments made to claims or arguments made to distinguish features of invention from prior art, estoppel will apply. So you have to be very careful while making any amendments to the claim during patent application prosecution, or any arguments which you are making during prosecution or with the examiner during interview, because these amendments argument, they may create estoppel. Prosecution history estoppel may apply even when amendments made for reason other than for the reason of patentability. One effective method of controlling prosecution damage is to argue the language of claims whenever possible, without providing applicants personal interpretation on scope of claim in response to amendments. Prosecution history estoppel may prevent infringement under doctrine of equivalence. Doctrine of equivalence infringement is a type of infringement by which infringement is by an equivalent, not directly by whatever has been claimed in the patent claim. So the infringing product is not exactly the same as whatever has been claimed in the patent, but it is similar to whatever has been claimed. It is equivalent to that of whatever has been claimed. That's why it is called equivalent or doctrine of equivalence. So when during patent application prosecution, the applicant surrenders some equivalent of the patented invention, so that surrendered equivalent will be there in the prosecution history, and that surrender equivalent will create prosecution history estoppel. It will prevent the applicant from later on claiming that equivalent which he has surrendered during application prosecution. Now later on he cannot reclaim that surrendered equivalent in infringement case filed by applicant for that equivalent which has been marketed by some person. So that's why prosecution history will apply to whatever has been surrendered during prosecution of the patent application, and later on the applicant cannot claim that equivalent which was surrendered during prosecution, cannot reclaim that equivalent and cannot claim for infringement of that equivalent because that equivalent has already been surrendered by him during application prosecution, and there will be no infringement of product which is marketing that equivalent because that equivalent is not covered by covered directly by patent claim, but it is the equivalent which has been surrendered by applicant during prosecution, and that surrendered equivalent cannot be reclaimed later on during infringement case. That's all in this presentation. Thank you very much.